Alright, so this is Decent We the People News. Okay? Not an attorney. Okay? I am not giving legal advice. Okay? However, I may or may not give my opinion, people. No more, no less. Just opinion. So do not take it as legal advice. Why? Because I'm not an attorney. Now, that being said, I never look straight forward. I always look around me to be able to protect myself by any means necessary, and sometimes I do listen to attorneys. Alrighty. Now, that being said, this video is without prejudice and or without recourse, okay? But I did think this was interesting. Top 5 things that you need to know about. Now, this is armed attorneys, okay? And I believe they're out of Texas area. However, this attends to everybody, all right? And they're speaking more along the lines of what may be happening if, you know, that you had to protect yourself, okay? However, this is overall because these 5 words, they still actually use. Whether you audit the police, whether you get tickets, whether you do this, whether you do that. All right, these 5 questions, especially if you've been played hardball on 1 or 2 questions, they're going to go to other questions. But they want to try to get these 5 questions in there. Okay? So that's the reason why I'm doing this video, is to learn basically the 5 questions that you really do need to know. Alrighty, let's go.
Armed attorneys, today we're talking about the 5, maybe 5.5, 6 tactics that police employ to get you talking. Now, why this is such a big issue. You've just been involved, maybe a self-defense incident. The stress of the situation is really upon you. Police want you relaxed. They want you talking. They want you feeling like they're on your side in order to incriminate you. And that's what we're going to be talking about. We're going to be talking about these tactics and why it's so important, because if you are familiar with these tactics, I mean, you're really going to be in the top 1% of folks interacting with law enforcement. You're going to be in such a better position. And so we have to talk about it. But before we begin, show your support for the Second Amendment by hitting that like button.
Yeah, and so this is why this discussion is so important, because I think generally, if you're watching this channel, you know the police can lie to you. You know that.
Or you have to tell me. If not, it's entrapment.
But it's really good to know ahead of time what kind of lies they will employ to get you talking, to get you incriminating yourself, particularly in the wake of some sort of firearm or defensive incident. Because if you can, on the front end of things, know what to expect, you are going to respond better. It's just like muscle memory with your firearm, right? I mean, it is knowing, it's muscle memory for your brain.
Yes,
right?
exactly right.
So let's jump in. Richard, number 1.
Number 1 is, I'm just trying to get your side of the story. Now, this kind of has a lot of implications in it. They already have a story. Now they just want your story. Why do you see this? And this comes up, I've seen this in my practice all the time. Why do you think they use this so much?
You know, it is to me, I mean, it harkens back to like, oh, I'm a neutral arbiter. You know, I'm going to look at both sides and make a fair determination. I mean, you know, we can say 99% of the time, the guy who gets his story in first is the victim, and the next guy is the criminal defendant.
That's the other story.
Exactly, right? So at the point that, hey, man, I just want your side, it's not about getting your side. You are already the suspect. You are already as good as arrested. And anything you say at that point is only going to, it's going to corroborate to facts
that that's the key word.
That the initial person has already given them, and it's going to make your prosecution easier.
Yeah, that brings us to number 2. If you don't talk to me, I can't help you. I hear that come up in my practice all the time. And I think this is why this one is used. I mean, let's jump back to Miranda warnings. You know, everything you say can and will be used against you. Noticeably missing from that statement is everything you say to me can be used for you.
Mm-hmm.
And so we rarely see, I mean, I've seen it. I mean, it does happen. I've seen this happen where people talk themselves out of charges. I will tell you that is a fraction of a percent. The other 99.999% of people talk themselves into charges. And I've seen cops say, hey, if you don't talk to me, I can't help you. I mean, what do you see?
Yeah, this is a very similar lie to number 1, to get you talking, but it's important. You will probably hear both of them. I have, you know, virtually every case I look at, I see the officers say both of those things. And again, we want to believe that law enforcement is there to help us. And I think this really plays off of that belief in most of us, right? I mean, we're were brought up, law enforcement's there. They're your friends. That's who you call when you need help. And then you have this officer and you're in this really stressful situation. You've been attacked. You've had to defend yourself. And the officer's like, hey, I'm just trying to help you. And I think it pulls up that instinct in us, like, oh yeah, this is my help.
Yeah.
They are not your help in that moment.
Well,
though.
especially for self-defender.
Okay, we're going to pause it right there. All right. Also, look at these things as a potential lawsuit against officers. Okay? Now, I haven't done it yet, but I am going to use it if and when I shall need to, right? And I'll just tell them plain out themselves, because I'm going to be looking at maybe a possible lawsuit and read them their Miranda rights back at them, right? You have the right to remain silent. Anything you say or do can and will be held against you in a court of law. Non-judicial or judicial. Do not mute or tamper with mine and your evidence that's in our investigation. Any tampering evidence will awfully get you into a year in prison. Do you understand? Something to that effect. Get your own. Alright? But what you are doing is giving them a notice of liability. We done a couple of videos back. Notice of liability, right? Where you're going to give them a notice of liability. And you're going to use that Miranda rights against them as a notice of liability, people. Think about it.
I mean, our interactions with law enforcement are probably speeding tickets, maybe a license or training course, maybe they helped you on a firearms range, and then this massive, this is life-altering self-defense event, and so you don't really have a point of reference outside of this. Career criminals, they interact with law enforcement all the time. They know exactly how to play the game. But for us folks who all of our interactions are of a helpful nature or a cooperative nature, when this happens, it's hard to kind of shift their mindsets. And I think a lot of people, they think, hey, if I help or if I go along to get along or if maybe this is the expedient thing to do, maybe I sleep in my own bed tonight. But I think what they don't think about is the long-term ramifications of maybe incriminating yourself, not talking to them with a lawyer present. These can have big, big implications.
Well, that's a really good point, because I tell my clients that all the time when they say, well, what if, the lawyer isn't there yet? What if I don't have a lawyer and I want to go ahead and tell my story, or else they're going to arrest me? And yeah, they might arrest you if you don't talk to them. However, and this is the point Richard's making, one night of discomfort while you get a bail set and you get your case rolling versus potentially every night for the rest of your life because you said the wrong things. A huge distinction. Don't take that immediate comfort. You are playing the long game after a self-defense incident.
And that brings us to number 3, which is
I do agree with that, right? Because that's exactly what they're doing. They're using trickery of words to get you caught up in their web. Okay? And sometimes if you're not in a habit of it, you're going to fall into that web and be stuck. So be very, very careful, people.
arrest you for obstructing an investigation, and besides being something we maybe see on TV, this isn't the law in, I would say, most states.
No, and this one's near and dear to my heart because about a year ago, I actually was almost arrested for obstructing an investigation.
Yeah, how dare you try to help your client?
Yes, yeah. In my defense, I was on a shooting scene, and I was instructing my client because they weren't going to let me be there for his statements. They're taking him downtown, and I'm screaming into the squad car, "Invoke all your rights! Don't say a word!" And then here we are, a detective's calling the DA's office trying to get him to take charges on me, and luckily they did not. Although I think it would have made pretty good headline news.
Yeah, probably.
But I guess anytime I can avoid a bologna sandwich and wearing someone else's underwear, I'll go ahead and avoid it and skip the headline news. But yes, first of all, let's look at criminal defendant, lawyers aside, right? Criminal defendant versus witnesses. If you are the guy accused of a crime, there is nothing that says you have to be cooperative, right? In fact, we have the Fifth Amendment privilege that says you do not have to incriminate yourself. You can remain silent.
Let's pause it right there again, people. And it just brought it to my attention just because my head was spinning, right? What really is 100% you need an attorney if you cannot use the attorney at that particular time? right? You may need that support at that time. Not later on, people. Not later on. She was there instructing him. However, young lady, check this out. Use that as your First Amendment. Free speech. To your client. Now, how is that impeding the investigation? Alright? If you ever see this video, I'm not big enough for you to do so, but hey, it is what it is. But, that being said, we go back into the number one issue, right? She was there. They was wanting to get her for, interrupting. But, wait a minute. And her job is to protect her, her client. Just sit and think about that. Now, again, that's just my opinion. My opinion only. I'm not giving legal advice. Because I'm not an attorney. But it just seems to me if I can't use it at the most important time, then technically what do I need an attorney for? Because an innocent man, that would be me, are fixing to go to jail. And they're going to put an innocent man in jail. And they're going to deny me my attorney at that particular present time. Just a thought.
There are things you can't do, right? You can't destroy or hide physical evidence. You can't affirmatively lie in the course of an investigation. Generally, there are state laws against that. You can't actively resist arrest.
Yeah, physically resist, yeah.
Yes, but, you do not have to cooperate. You are not going to be arrested for not cooperating. And then, of course, we have the issue of just witnesses. If you're an attorney or someone in your state and you do have a law about witnesses just staying silent who could be arrested, I would love to hear, because I'm sure it exists out there. It doesn't in Texas, but we
a couple of videos back, did I or did I not make a copy of a man being arrested? Of course, that being said, he spoke, and when he shouldn't have spoke, right? So there, like again, that video that I showed a couple back, he said one thing, said another, and now he got himself into a quandary. So even as a witness, keep your mouth shut. Alright? In the state of Texas, you don't even have to identify yourself. Okay? You just cannot give false identification. You check your own states, whoever's outside of Texas. But in Texas, you do not have to identify yourself, even being a witness. Okay? 3802.02. Alright? So if you are ever a witness and they try to do this to you, you just bring them up that number.
see this threat used all the time. And in Texas, it's entirely empty, which is, oh, you witnessed this, but you won't talk to me about it? Well, I'll just arrest you for obstructing my investigation. You cannot do that in the state of Texas. I'd love to hear, if it's different across the country. But
yeah, and I'll add one caveat, which is, non-testimonial, would otherwise be speech. Let's say you're arrested. There are some things that aren't incriminating, or the courts have said aren't incriminating, generally providing your name, your date of birth, your address, your photograph, your fingerprints. Those types of things, courts have said,
Wrong. Alright, just like Terry versus Ohio did that bypass of the Fourth Amendment by using the trickery words of detained by helping out the officers against the people. That's exactly what they did on the Fifth Amendment. They're saying you're allowed to incriminate yourself, even though we're not going to call it incrimination. But think about this. Where does it say in your state constitution and the federal constitution, except your name, address, so on? Right? No, they're supposed to figure this out on their own. That's the reason why the warrant says description. Okay? Doesn't say name, it says description. By the way. Alright? So even with that, by the Fifth Amendment, and I don't know what the Texas is, I have to really look at that, but by the Fifth Amendment, that is incrimination, no ifs, ands, or buts. And the courts actually created a bypass to violate your rights of not to incriminate yourself, because they just right there named off what, 5 different things just to incriminate yourself to get the court started, people. So think about it. Where does it say? Except all these things down here. Alright.
That's non-testimonial evidence, couldn't be used for or against you. So typically, we see most states have laws in the book saying, "Hey, you got to give your information."
They can't use your name against you. That's exactly what they're doing. Oh, well, your DNA, we can't hold that against you. That's exactly what they're doing. We want your address. We're not going to hold it against you, but that's where we're going to find you. They are going to hold it against you, people. All right, and by the way, just clarification. I'm not an attorney. I am not giving legal advice, okay? It's just my opinion, okay? It's me not thinking straightforward. I'm thinking around me, all right, to be able to protect myself by any means necessary, all right? I'm sorry. I should redo this video, but I'm not. Let's proceed forward. It's not going to be held against you.
Once arrested. And that brings us to number 4. I see this in a lot of crime documentaries because it's used to solicit what looks like a lot of false confessions. The police saying, "I have it on tape," or there's some variations. "We have a witness," or "Your fingerprints are at the scene," or "We have DNA." A lot of times this is used as just kind of a trick. Really, it's a lie. A lot of times they don't have it on video. They don't have DNA. They don't have fingerprints. Just to kind of see the person squirm in the chair. I see detectives, they kind of pull that, grenade out, throw it into the other person's court, and just kind of wait and see and watch how they react.
Yeah, and it's just, again, these are all tactics and these are all lies used to get you talking. So, whether it's true or not, let's say that you committed an offense and police are saying, "Hey, I've got something that, I've got some scientific forensic evidence that says you committed the offense." You might be trying to talk your way out of, "Well, this is why my DNA happened to be on the scene. I forgot to tell you that I was in that apartment 2 weeks ago," or whatever it happens to be. But let's say that you know that you did not do the thing they're accusing you of, and they say, "Well, I've got a witness who says you did it." That's really likely to get, just good, innocent people like, "Well, how could that be?" Because, and then you start talking about the incident,
Justify it.
Exactly. Like, "I know that can't," and you want to roll with it, and it's a great way to get you talking. And once you're talking, again, it is all going to be used against you, not for you.
And this is how it destroys self-defense claims. You give "Hey, this is how I defended myself, XYZ. And they say, "Hey, we got a video of it. It didn't happen like that." And then the person's wheels start turning and they try to think of, what's a different way of explaining, I'm still going to tell the truth. I'm still going to explain XYZ. I'm just going to explain it in a different way. Maybe the officer will understand then. But now you have 2 different statements, and you've just destroyed your self-defense claim because you have 2 statements about how it went down. And so
they're going to make you look like a liar.
Yeah, exactly.
Even if they're not totally different statements. That's what they do. They take that's why that's our big thing with our clients is one statement. Your first statement has to be your best statement. The reason is tiny inconsistencies between statements are going to be blown up in court. And so it is just incredibly important that you not do that.
Yeah.
That being said, that's exactly what they're doing. They're also using trickery of words for you to use trickery of words. Okay? To better clarify what you're... Anyway, what they're doing is tricking you into you tricking them, and to get you into this bondage, into these lies, these webs that you cannot find yourself out of now, because number 1, you spoke. Right? Number 2, you changed your story. Right? Regardless of how innocent you are, they, not these people here, but the courts are the biggest liars. They can see a lie a mile away. And if you're not lying, they still use it as a lie. Just even by the trickery of words. Even though they're not lying, they're using trickery of words to make you believe the truth within the lie.
That brings us to number 5, which is, and I hate this one, if you don't let me in, I'll just get a warrant.
Mm-hmm.
And we see this, and this comes up in ATF context, this comes up in police searching context, but really, have you ever seen, I'll tell you, in my practice, I have not seen the police follow through with this threat.
Very rarely. I mean, it is, it's definitely at least a half truth, if not a full lie, because generally speaking, if they had warrants, they would already be serving you with a warrant.
Yeah.
Or, particularly when they get kind of mad about it, it's because they know there isn't enough probable cause for a warrant. So they want you to cooperate, yes.
What's so important about this is our general rule is the police can't seize people, seize property, search places that we have an expectation of privacy in without first obtaining a warrant. That's the general rule, and we have a ton of exceptions to that warrant requirement, the biggest being consent. So, police officer, you're standing on your porch. Hey, can we come in and search your house? Nope. Okay, well, I'll just go get a warrant if you don't let me in right now. Well, the wheels might be turning in that person's head. They're going to get in eventually. I'll tell you, if they wanted a warrant, they would have gotten a warrant already for the most part. But here's what happens if you let that officer or agent search at that point in time. You have provided consent. That one of the biggest exceptions to the warrant requirement in all your claims in court that it was an unlawful search or that they violated your rights or that evidence should be thrown out. Those things kind of go to the wayside in the, when we have consent. So it's really important. Invoke your rights, stick to your guns in those scenarios. And if the police really have enough to arrest or to search or to seize, they're going to do it. Yeah. They're going to do it. But this brings us to our last,
That being said, you know how I am about that, right? Consent, volunteering. We're doing all these things by tacit agreement or within the silence acquiescence. Consent and volunteering things is a big no-no, people. We need to realize how often, and it's become a habit, and they train us to be in these habits. Be honest, okay? By your schools and all that. I talked about it before. During the beginning, it was mandatory for public schools to go learn our rights, Constitution. All right? Now we're learning other things, and not one time is the Constitution ever brought up. Why? Why? When that's what the job was for public schools in the first place.
we call it our half lie because it's technically the truth.
It's technically true.
But it's a little sneaky, and that is you're not charged with a crime. How do you see this come up in your practice?
Oh gosh, I see this all the time. And it is in the context of, hey, just talk to me. Just tell me what's going on. You're not charged with a crime. And that makes you think, well, I'm just a witness, or potentially I'm the victim. When realistically, they're saying this to you, sometimes minutes before you actually are officially arrested, sometimes a little bit longer, but it's technically true, but it's meant to relax you. It's meant to get you talking, to give that information that they want before formal arrest and charges. So it's I guess technically that's why it's maybe a little half truth.
Yeah.
It's technically true, but it's only true for moments after they say it. Generally.
Yeah, they're saying you're not under arrest while you're standing on your front porch with your hands in front of you trying to explain what happens. Yeah, technically you're not in cuffs in the back of their car and they haven't called it in yet.
Mm-hmm.
That's really what we're talking about, a distinction here, but. It is sneaky. It does get people talking. It does kind of relax them, puts their guard down, and you got to look out for it. But if you understand them, you learn the...
Detained is trickery. All right. Once you've been seized, you're under arrest. Whether you believe it or not, let's just, for argument's sake, you believe that detained and arrest is two separate things. What will it hurt you to go ahead and convince yourself it's arrest to keep you safe from making that mistake and getting you in trouble with them, right? Any type of seizure is arrest. That's just my opinion. I'm not an attorney, okay? However, for y'all's safety, even if you're detained, hush, hush, hush. Just saying.
These things, you're going to be in the top 1% of folks interacting with law enforcement. Now, there are those scenarios, we go train, we become proficient, we know...
Top 1% out of 365 people that actually has the will to actually do what these people are actually saying. Most of the time, everybody goes in, gives consent, volunteers information and this, that, here and there to try to make their discomfort a little easier with the officer. And that right there is what they want. They just tricked you into believing that you're comfortable or making yourself more comfortable.
know how to shoot defensively. We have our plan, but right after we find and we talk to folks, right after you're involved in a defensive incident, I hear every single person, and you're going to think this in your head. What do I do now? I mean, maybe you've already called 911 even, and the police are on their way. What do you do at that point in time? And there is a right answer.
What you do and what you don't do can make or break that self-defense claim. It actually can even lead to more charges. That's why, thankfully, we have a video here to teach you what to do and what you need to know before the police arrive. And until next.
Alrighty, this is We the People News. 5 elements, 5.5, that you may want to be aware of for any interactions with the officer, just not because of self-defense or whatever the case may be. Any interactions, period. This is We the People News. Bye, y'all.